The theoretical and procedural failures discussed in the previous chapters come to life most vividly in real-world case studies. These stories, drawn from across the United States, expose not only the impact of individual dishonesty, but also the systemic enablers that allowed these failures to occur, persist, and replicate. In each case, an officer's failure to tell the truth, whether in the field, in a report, or in the courtroom, was not merely an ethical lapse, but a breach that rippled outward, compromising investigations, tainting prosecutions, harming innocent individuals, and undermining the very foundations of public trust in law enforcement. Case studies play a crucial role in illustrating the contours of failure. They show how truth breaks down in practice, how oversight mechanisms are bypassed or ignored, and how those in power respond if at all when candor is violated. These stories are essential for understanding the lived consequences of systemic deficiencies. They are also tools for change, offering insight into the patterns and warning signs that precede institutional collapse. This chapter introduces a curated selection of such cases examples that range in scale from massive corruption scandals to localized incidents with outsized implications. Each case represents not merely an outlier, but a symptom of deeper, structural problems. Taken together, they form a mosaic of a justice system vulnerable to distortion when truth is neither protected nor prioritized. Why case studies matter. To understand the gravity of candor failures in law enforcement, it is essential to move beyond abstract principles and examine how these failures manifest in practice. Case studies allow us to trace the trajectory of dishonesty from the moment an officer bends the truth, to the courtroom where that truth is accepted, to the prison cell where an innocent person may sit for years. They demonstrate that dishonesty is not a victimless act. It is an accelerant that fuels injustice. More importantly, case studies are diagnostic tools. By analyzing the actors involved, the decisions made, and the mechanisms that failed to catch or correct the misconduct, we gain a clearer picture of what reforms are needed. Each case becomes a microcosm, an encapsulated lesson in what happens when the legal and ethical obligations of complete candor are abandoned. In selecting case studies for this chapter, a few criteria were used. The presence of a clear or documented act of dishonesty by law enforcement personnel, a demonstrable consequence that resulted from that dishonesty, e.g., wrongful conviction, mistrial, civil settlement. Systemic factors that enabled or failed to prevent the misconduct. Lessons that can be drawn from the case for broader application. Common patterns in candor failures. Although the factual circumstances of each case vary widely, a review of high-profile and lesser-known incidents reveals several recurring patterns, indicators of systemic breakdown rather than isolated moral failings. Institutional tolerance. In many of the most egregious cases of officer dishonesty, misconduct was not only ignored but actively tolerated. Officers were allowed to resign rather than face disciplinary hearings. Internal affairs investigations were slow-walked or strategically closed. Department leaders shielded problematic officers from scrutiny out of loyalty, political pressure, or fear of damaging public reputation. This tolerance creates a feedback loop. When officers see that dishonesty goes unpunished, it becomes normalized. Patterned misconduct across officers. Another frequent feature is that misconduct is rarely limited to a single bad apple. Departments that tolerate dishonesty tend to produce multiple officers engaged in similar behavior. Whether it's falsifying reports, coercing confessions, planting evidence, or lying under oath, the behavior tends to cluster within units or across shifts. This suggests a cultural and institutional failure rather than a rogue anomaly. It is not a failure of character alone, it is a failure of leadership, oversight, and accountability. Disproportionate impact on vulnerable communities. Nearly all case studies of officer dishonesty disproportionately affect marginalized populations, particularly Black, brown, and low-income individuals. These communities are more likely to be over-policed, less likely to have access to robust legal defense, and more susceptible to coercive tactics. When officers lie in these contexts about the basis for a stop, the presence of contraband, or a suspect's alleged statement, the cost is often borne by those least able to challenge it. Candor failures thus perpetuate structural inequality. Failure of prosecutorial gatekeeping. Many case studies reveal that prosecutors either failed to detect dishonesty or knowingly relied on dishonest officers to build cases. In some jurisdictions, Brady and Giglio compliance was minimal or non-existent. Prosecutors failed to disclose known credibility issues to defense attorneys or continued to use officers who had previously been found to have testified falsely. Whether from negligence, strategic ignorance, or institutional pressure, this complicity deepens the harm and delays justice for years, sometimes decades. Judicial deference and passivity. Courts have an independent duty to ensure that testimony is truthful and that legal proceedings are fair. Yet in many case studies, judges were reluctant to make credibility findings against officers, even in the face of strong evidence. This judicial passivity sends a dangerous message that the courtroom is not a place of truth-seeking, but of truth-selecting. When officers learn that their statements will be accepted at face value, regardless of their veracity, the system becomes a stage performance, replaces honesty. Consequences for victims, officers, and communities. The consequences of officer dishonesty in the cases examined are both immediate and long-lasting, affecting not only individual defendants, but entire communities and institutions. Individual harm and wrongful convictions. The most direct consequence is borne by the wrongly accused. Individuals who are arrested and convicted based on dishonest police conduct may spend years or decades in prison. Even when convictions are overturned, the scars remain lost time, fractured families, destroyed careers, and enduring trauma. For some, exoneration never comes. They serve their full sentences carrying the weight of a false conviction. Collateral damage to law enforcement legitimacy. Every proven instance of officer dishonesty undermines the legitimacy of the broader law enforcement community. Even officers who uphold their duty with honor and integrity find themselves met with public skepticism. Witness cooperation declines. Community trust erodes. Crime solving becomes harder. Departments then rely on increasingly aggressive tactics, justifying them with claims that the community is uncooperative when, in truth, the community has been betrayed. Institutional and financial fallout. When officer dishonesty is exposed, especially if it leads to civil rights lawsuits, the financial consequences for municipalities can be staggering. Some cities have paid out tens or hundreds of millions in legal settlements stemming from patterns of police misconduct. These costs are not borne by the officers or even their departments. They are borne by taxpayers, including those victimized by the misconduct. The institutional damage also includes vacated convictions, overturned sentences, and the need for costly retrials or reviews. Structural lessons from the case studies. From these case studies, several critical lessons emerge, lessons that must inform future reform efforts if systemic change is to occur. Early warning systems must be strengthened. Many of the officers at the center of major scandals had long histories of misconduct. Complaints had been filed. Reports had raised red flags. Colleagues had voiced concerns. Yet these early warnings were ignored, buried, or procedurally dismissed. Departments must develop and enforce early warning systems that identify patterns of dishonest behavior and take preventive action before the damage becomes irreversible. Brady/Giglio compliance must be systematic. In every case where a dishonest officer testified in court without disclosure of their credibility issues, the failure can be traced to weak Brady/Giglio enforcement. Prosecutors must maintain up-to-date lists of compromised officers and disclose their status to defense counsel in every relevant case. Police departments must proactively inform prosecutors of any officer misconduct with potential impeachment value. There must be no ambiguity about who is responsible for tracking, updating, and disclosing this information. It must be a mandatory, standardized practice. Prosecutors must treat dishonesty as disqualifying. Using officers with known histories of untruthfulness to support criminal prosecutions is not merely a legal risk, it is an ethical violation. Prosecutors must adopt a zero-tolerance policy for perjury and false reporting. Officers who have been found to fabricate evidence or lie under oath should be treated as giglio impaired and removed from any prosecutorial reliance. Continuing to build cases around such officers erodes the moral authority of the office and places convictions on unstable ground. Courts must be willing to act. Judges must be empowered and encouraged to identify and sanction dishonesty in their courtrooms. This includes making explicit credibility findings, suppressing tainted evidence, referring perjury cases to outside investigators, and excluding officers who have demonstrated a pattern of untruthfulness. Passive neutrality is not enough. The court is not merely a venue, it is a gatekeeper of fairness. Communities must be given access to the truth. Public access to disciplinary records, internal investigations, and Brady/Giglio lists is essential for meaningful accountability. When misconduct is hidden behind layers of bureaucracy, confidentiality laws, or union protections, the public loses its ability to demand change. Transparency is not punitive, it is protective. It ensures that communities know which officers they are dealing with, and which departments are willing to stand behind the principle of complete candor. Each of the following case studies will be explored in detail through separate prompts: LAPD Rampart Scandal, George Floyd Case, and Ducon and the Massachusetts Crime Lab, LASD Deputy Gangs, Cook County, Illinois, Chicago PD Corruption. Conclusion: the case studies of candor failures do more than illuminate specific acts of misconduct. They lay bare the fault lines of a system that too often confuses loyalty with integrity, conviction with justice, and silence with stability. Each case shows what happens when complete candor is not just forgotten, but actively replaced by its opposite. Yet these failures also serve as blueprints for reform. They point to the policies that need changing, the roles that require scrutiny, and the cultural norms that must be dismantled and rebuilt. In the next chapters, we will turn to the structural tools designed to address such failures, starting with the Brady and Giglio lists. But we do so with the knowledge that no policy, however well-crafted, can substitute for the moral commitment of individuals. Truth begins not with the institution, but with the person. These case studies are a warning, but also a call to recommit ourselves to the first duty of every officer: complete candor. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.